President Cyril Ramaphosa has written to the Deputy President of the Pretoria High Court, essentially barring Public Protector Busisiwe Mkhwebane from actually releasing the details of some of the evidence that she has, which forms the basis of her report into President Cyril Ramaphosa. Well, Ramaphosa has requested certain information contained in the record of the Public Protector should not be disclosed. Now, this is after reports about Ramaphosa's alleged involvement in the CR17 fundraising campaign that were leaked to the media. Now, SABC News has verified the authenticity of this letter. Let's now talk to my colleague Sakina Kamwendo. A very good morning to you, Sakina. Thank you so much for joining us. Welcome.
Working very hard on Women's Day.
I can imagine. I can imagine.
Yeah.
All right, now, Cyril Ramaphosa essentially doesn't want the public to know where he got the CR17 campaign funds from. I mean, this muddies the waters even further and deepens the mystery.
You see, and I'm not sure if we can take it that far, that he doesn't want people to know where the funds came from, because at this point, we're not even sure exactly what he wants to have sealed exactly. So perhaps just to go back a little bit, the president, of course, has taken the Public Protector's report on review, as we know. So what has happened now in that application where he asked for the review, what would then happen is then through a motion of a notice of motion, he would then ask for the documents. Yeah. This is now when you get to hear the evidence relating to the details yes. of this particular review that he's asked for. So he's asked through a notice of motion to have those documents, to have access to those documents. So those will be sent to the court. And once they are, then they become public record. Once those documents are sent from the Public Protector's office to the registrar. Okay. So what we now see is that Cyril Ramaphosa's lawyers, Harris Mojapelo, Nupen Mojapelo, they have now written to the Deputy Judge President, and they are saying that they would like the confidential information to be kept confidential. So they want it sealed, and which is very interesting because through that notice of motion, they actually, in paragraph 9, and I actually had a look at that, they actually specifically ask for this particular information. So they've asked for the information, now they want it to be sealed. But the question then becomes, what exactly do they want sealed? Because as it stands, they haven't had sight of those records that the Public Protector relied on to arrive at the finding against the president. So what do they want sealed? Yeah. Exactly, because they haven't had sight of it as far as we can judge. And this is what they are asking for. They want that record to be sealed. They also contend that the information was unlawfully obtained by the Public Protector's office. And we know that the Public Protector's office, they've come out and said that there were whistleblowers in this instance. So the information came from whistleblowers. So does the information become unlawfully obtained if it's provided by a whistleblower? So these issues also, need to be argued out. And then, of course, they also contend that the Public Protector once again overstepped. And this is by going beyond the scope of the investigation. If you remember, this particular investigation came about as a result of an application to the Public Protector by Musi Maimane and Floyd Chibambu with regard to that 500,000 Rand Bosasa donation yes. to the president's campaign at Nasrec for the ANC. Yep. So even there's another argument that may be put forward that the Public Protector is supposed to look at matters relating to public officials and not members of the ANC per se. But as I say, there's another argument to be had there with regard to that line between the ANC's elective conference and the president in his capacity as president, deputy president. All of those things are still to be argued out at some point.
Sakina, whether the information was legally or lawfully obtained or not, it doesn't change the contents of the report. I mean, just looking back at the leaked emails by News 24, and I guess the information that President Cyril Ramaphosa doesn't want to be exposed is much more groundbreaking and much more hard-hitting against him.
But this is exactly it. And I think through what they say in the letter, because at no point do they dispute the contents of what may come out. But let me just repeat, let me remind us, as far as we know, the president's team hasn't had sight of the record that the public protector relied on to arrive at this finding, because they've asked for it through that notice of motion, and now they are saying, hold up, before you even get there, because they realize that once it's submitted to the registrar, it becomes public record. Yeah. Everybody has access to it.
So he's basically panicking, not knowing what's in that report. He's in panic mode.
It almost would suggest that. It seems, that this would be a sort of a preemptive strike almost, just to see, maybe there's too much contained in there. Let's keep it closed. But it's a tacit approval, I would say, of the veracity of the contents, because you're not disputing it. You're simply saying people may be prejudiced if you put this information out into the public domain. That's the one way of reading it. And the other way of reading it, of course, is that according to the Constitution and the laws of the land, the POPI Act, people have a right to have their private information kept private.
Yeah, and we see that President Ramaphosa and Buziwe Mkhwebane are in each other's throats, and the president saying on the one hand that there is actually no time limit specified in Buziwe Mkhwebane's remedial action, and that, arguing that the appropriate route was to await for Pravin Gordhan's review process. And then on the other hand, Mkhwebane is saying that, this was not implementing the actual remedial action, and that Gordhan should have at least applied for an interim interdict instead. So this is sort of a valid argument, don't you think?
It's very convoluted, because you see now we're talking about separate cases now. There's, of course, the issue at hand that pertains to this Harris Nupen Molebatsi letter is the president himself and that 500,000 rand donation from Bosasa. That's what this relates to. Then there's, of course, the issue involving Minister Pravin Gordhan. It's the one from yesterday, whereby, again, the president then said that he would wait for the other case now involving Pravin Gordhan to be finalized before he decides to take action. Yeah. And that was the one where he essentially was victorious yesterday. And in that case, and in the other one, the public protector, if you will remember, actually opposed the matter in court. Whereas here, in the matter of Bosasa, she didn't. So this goes directly to hearing the merits of the case. And I don't know whether perhaps they were caught slightly off guard there, the president and his team, with regard to that strategy. Maybe they anticipated that she would oppose and she didn't. Yeah. And unfortunately, it's now moved straight to the point whereby this information now is about to hit the public domain, and the president is opposing that.
Right. We're now joined on the line by the spokesperson of the Public Protector's Office, Oupa Sekgalo. Very good morning to you, Oupa. Thank you so much for joining us. Has the Public Protector been served with the letter from President Cyril Ramaphosa's lawyers?
Yes, we have just got confirmation from our attorneys that that letter was received last night. And the Public Protector is yet to engage with it because she's out of the country at the moment.
If I may also just, Mr. Sekgalo, with regard to what is contained therein, and perhaps just from your side, the process that needs to unfold. As I understand it, the notice of motion was effectively filed by the President's team. And at what stage are we for your team to actually submit that evidence to the registrar?
Well, from our attorneys, we are supposed to be filing that record of our investigation now that papers have exchanged and all of that. But we are still within, the deadline of filing that particular record. But if the latest development now, meaning the letter that is currently doing the rounds on social media, the Public Protector will then have to engage her legal team and then see how we get around the issues that are being brought up by the President in that particular letter.
So one of the other issues, Mr. Sekhalwe, pertains to whether the president and his team have had access to the documents that the public protector relied on to arrive at her determination. Have they?
Well, I'm on advice not to engage in the nitty-gritty of those matters, because those are essentially issues that will form part and parcel of the review itself, which is yet to be heard. So I'm going to be a bit restricted in terms of what I can share in that regard. Safe to say that the public protector is confident that she followed the law throughout her investigation of this particular matter.
So, and that's fair comment, but just with regard to some of the arguments being made that are being charged in the letter from Harris, Newp and Mulebatsi, one of the things they talk about is the public protector overstepping the scope of the investigation. So without necessarily getting into details, what is the procedure in this regard whereby the public protector was asked to look into a particular donation that was made to a campaign fund and ended up finding other things as well, and then bringing that into the report? Is that something that is commonly done?
Well, the public protector has spoken on this matter time and again to say the complainant or one of the complainants in the matter requested her to look into three issues. One, whether or not the president misled Parliament. Two, the nature of the relationship between the president and USAFA, or African Global Operations, and as well as suspicion of money laundering. And that's what she looked at. But then, during the course of the investigation, she had to rely on case law. I'm not sure if you remember a case that Advocate Mushwana dealt with a couple of years back. It was called the Oilgate matter. It involved Petro SA and funds that ended up finding their way into the coffers of the governing party. That matter came to the fore as a result of a story by the Mail and Guardian. And the public protector investigated and found nothing wrong. The report was taken on review, and the Supreme Court of Appeal ruled on that matter that the public protector need not confine herself to what has been brought before her. In other words, they said she should follow the money. If she sees that this thing is leading to something else, she need not stop there. She must follow through with that particular matter. And she speaks unambiguously about that in the report to say, this is what I'd like to end up going into this terrain.
And with regard to obtaining information unlawfully, when it comes to whistleblowers, what does the law state? Well,
we have seen that the claim that the public protector may have obtained information unlawfully and so forth, but that is further from the truth. And the public protector will ventilate those issues in court at the right time. But all that she can say is that she has done everything by the book in this case, including evidence that was brought to her attention. And she can get information by way of a subpoena to anyone, basically, not just people in government, even private persons. She can subpoena information from them, but she can also receive information from whistleblowers. And whistleblowers could be people that work with those who are the subject of her investigations. And they bring this information to the public protector's attention because they are concerned. And I'm not saying that was the case in this matter. I'm just speaking general to say that usually happens in a lot of our investigations. And that is why we always say that whistleblowers are critical to the fight against wrongdoing in both private sector and public sector, and they need to be protected at all costs.
And perhaps just a final one from my side. Is there, Mr. Sekhalwe, any precedent for this type of matter whereby there is a notice of motion filed and then there's a request to have the contents of that information sealed?
Not to the best of my knowledge. It may have happened in the past, but I can't confirm that. But I suppose the parties are always at liberty to approach the courts with that kind of request. And it is then up to the courts to, weigh all the arguments advanced in that regard and then make a decision that would be just in the circumstances.
All right, Mr. Opa Sekwale, thank you so much for joining us. That was the spokesperson in the Public Protector's Office, Mr. Opa Sekwale, just responding to the papers that have been served to the Public Protectors from the Office of the President, essentially barring the Public Protector from revealing the contents of that, of whatever evidence that the Public Protector has to the public. And yeah, speaking of the precedents, do you think this is setting very dangerous precedents, particularly for the public office of the Office of the Public Protector?
I don't know, because, you know, I suppose, as Mr. Sekwale points out, if it is legal, if it is lawful, you know, it goes. You would do whatever you need to do. But it's going to be interesting to see what happens now, because the letter has been sent to the Deputy Judge President, and essentially where it was when they filed that notice of motion, then it meant that all the emails, all the letters, all the account numbers and all of that information that the Public Protector had collected would then, of course, be dispatched to the court. And we don't know what's going to happen now, because it had to be dispatched to the court, and it is supposed to become public record once it is with the registrar. So we wait to see what happens.
Yeah, and I was just going through the report a short while ago, and I see the name of ABSA features in that particular report, and it takes us back to, you know, that argument that was raised. The Public Protector saying that she actually sent a subpoena to ABSA to provide records of the bank statement of President Cyril Ramaphosa, and ABSA Bank tweeting that no such subpoena was received. They don't know what the Public Protector is talking about. This sort of deepens the mystery. Which
is what they are talking about in claiming that the information was unlawfully obtained. So these, of course, are the nitty-gritties, the detail that will become more evident once these matters are argued before a court.
Yeah.
For now, this is what the President, through his legal team, has contained. And, of course, we heard from the Public Protector's Office. They feel they didn't obtain this unlawfully. A whistleblower came forward with this particular information. So it's going to be interesting to see how they resolve it.
All right, Sakina, I'm going to let you go. Thank you so much for your brief. We appreciate your time.
Well, thank you.
That is my colleague, Sakina Kamwendo. She's been working tirelessly about this particular matter. All right, as you see on your screens right now,